Right. The next presentation is one of the XRP community's finest. This individual is quite literally part of an army. Mr. Bill Morgan and his company, they are sponsors of this event, Morgan Mac, and I believe they're also part of the lawyers and the legal team of Wave of Innovation. It's my absolute pleasure to introduce Attorney Bill Morgan.
Regulation in Australia is a topic, and it can be a dry topic. So I'm going to try and deal with it in two ways. Firstly, I'm going to look at what I think is the thinking behind where the policy towards reform and regulation is heading in Australia. And then secondly, I'm going to deal with a very important case in the Federal Court of Australia that was delivered about 4 weeks ago. So this is a really fundamental question. Is there regulation of crypto in Australia? It's an asset. Crypto is an asset. It's a form of property in a legal system. So therefore, to some extent, it will be regulated, even if people don't know where the boundary lines of regulation are. Regulations that we have at the moment are principally AUSTRAC, the Australian Transaction Reports and Analysis Centre, and then, of course, the Australian Taxation Office. So the Australian government got that part of regulation in order very quickly. And there's income tax if you earn income, such as rewards on staking. There's capital gains tax when you sell or exchange cryptos. And there's goods and services taxes if you use crypto as a payment for a good or service. And then finally, there's the Australian Securities and Investment Commission. And one of those policy guidelines has that statement, which makes it clear that the position of ASIC is that at least some crypto and some crypto activity falls within the Australian Financial Services licensing regime. Why token mapping? Token mapping is a foundational step, according to the Treasury, in getting the regulatory framework right for crypto. It is obvious that the government already knows that whatever crypto regulation whatever legislation is ultimately passed is going to intersect with the current financial services regulatory regime. That the real policy problem or concern is intermediary risk. That's why it's targeted at digital asset platforms. And that is obviously in the wake of XTX and all those other disasters over the last couple of years. There is a risk of conflicts of interest when you have a platform that is holding your crypto, allowing you to trade, and also possibly, depending on the product, like an earned product, dealing with your cryptos. So that really amplifies the intermediary risk that investors in crypto who have their crypto on exchanges. The focus of the Australian Treasury is not on the token. So it's on the activities of the intermediaries where they're primarily focused. Many digital assets are not financial products, but holding assets, custody of assets, is the regulatory anchor point. And that's the expression used in the second consultation paper. That's the regulatory anchor point where the government is particularly focused. It's pretty clear that tokens like Bitcoin and XRP are not considered to be themselves financial products. We don't need a case, I think, to tell us that in Australia.